Transferencia de tecnología, asuntos regulatorios y asuntos legislativos y reglamentarios. Ha asesorado a compañías nacionales e internacionales en una amplia gama de industrias. Ella tiene una vasta experiencia administrando portafolios de propiedad intelectual en Ecuador, la Comunidad Andina y América Latina. Ha sido miembro de varios comités técnicos del Instituto Nacional Ecuatoriano de Normalización para el estudio y la adopción de normas técnicas para la industria de alimentos y bebidas. Es cónsul ad honorem de Trinidad y Tobago en Ecuador, miembro de número de la Casa de la Cultura Ecuatoriana, sección de Ciencias Jurídicas. Fue delegada del Ecuador ante ACIPI. Cecilia.
Buenas tardes, queridos amigos y colegas. Les agradecemos mucho su presencia acá. En esta tarde, Mark Lieberstein y Tatiana Campello nos van a ilustrar sobre las cláusulas anticompetitivas en derechos de licenciamiento en propiedad intelectual, que pienso que es un tema que nos puede interesar mucho escuchar. Ellos nos ilustrarán desde las perspectivas de sus respectivas jurisdicciones, en el caso de Tatiana desde Brasil, en el caso de Mark desde Estados Unidos. Gracias Tatiana y Mark por estar con nosotros en esta primera sesión de la tarde. Vamos a comenzar con la exposición de Tatiana Campello. Tatiana es socia responsable del área de propiedad intelectual en la firma de Marest Abogados en Río de Janeiro, Brasil. Ella ejerce su práctica en Derecho a la Propiedad Intelectual, contratos, Derecho del Deporte y el Entretenimiento, biotecnología y también en asuntos de fusiones y adquisiciones. Tatiana fue presidenta de Licensing Executive Society Brasil. También fue presidenta del Grupo de Propiedad Intelectual del Lex Mundi, cargo que continúa ejerciendo, mediadora del Centro de Mediación de la OMPI, fue coordinadora de la Comisión de Solución de Controversias de la Asociación Brasilera de Propiedad Intelectual y por muchos años co-coordinadora de la Comisión de Transferencia de Tecnología y Franquicias. Coautora de varias publicaciones, entre las que se encuentran Business Laws in Brazil, de Westlaw, y Brazilian Commercial Law, A Practical Guide, publicada por Kluber Law. Ha recibido algunos reconocimientos en Chambers Global, and the World Leaders Patent and Licensing Lawyers, en Who is Who Legal International, y también ofrece sus conocimientos como profesora de la Escuela Superior de Abogacía y en talleres de capacitación de la Asociación Brasilera de la Propiedad Industrial. Con esto, pues les dejo con Tatiana y espero que el tema sea de su interés. Tatiana, por favor.
Good afternoon. I hope that everyone wake up after the lunch, and we have the pleasure to talk today about a very interesting subject. But first of all, I'd like to thank you, the organization committee, to invite me here today, to be here today talking with you, and also to our moderator, Cecilia, who very well organized the panel and put us together to discuss here today. The idea of the presentation is to show you the two different words, how they can get together. Let me just make sure that this is the introduction. I'm going to jump for the first topic already, and we are going to talk about how the IP world and the competition world, they get together. The idea is some of the issues that brings for IP and competition, they are complementary issues. We are going to see here today that one area is not apart from the other in the opposite way. They could be connected. But also there are some issues between the two areas that we are going to see different interests in. This is what I'm going to talk today. Also, when I was preparing the presentation, I realized that the topic of the presentation is MAN clause, the anti-competitive clause in IP agreements. And when we think about the which are the main clauses on IP agreements that could be characterized as an anti-competitive clause or not, we realize that, well, we should not talk about a specific clause or a specific agreement, but we have to think about how this is structured, how this will implicate in the market, what is the transaction by itself. And then our thinking about the two subjects is much more broader, is much more, is going beyond the IP analysis, is going to beyond the clause analysis. You have to really think about the anti-competitive rules and how the market, how the transaction, how the deal is in the context that we are dealing. This charter here trying to show you how the IP is governed or written in a more general way. We are having the intellectual property rights as encouraging innovation, giving the exclusivity rights for the owners for who develop that innovation, that technology. We have protected investments. It's always important that you make sure that when you develop something, when you create something, you have the protection of your investment by the exclusivity also rights under the IP protection. You also have the supports dynamic competition. As you know, the industrial property law in Brazil, it's against, of course, unfair competition as the international treaty as well. And therefore, the law incentivizes the fair competition, but never the unfair competition. And also the effective allocation of resource. If you're doing the right thing, you make sure that your resource is going for the right direction, for the right investment, and the right protection. And the licensing can lead more efficiency for exploration. It means that the owner of a patent or a technology or even a trademark does not necessarily mean that they have to use that direct. Maybe a license could be a good alternative for the owner of that technology and also for the licensee, which will have the benefits, not avoiding to invest a lot of money and time on research of a specific technology if they have the possibility to receive that license and use that license as an alternative to build the market, to innovate, to create some products to the market. Also, increase the value of the IP. The license also stimulates the value of the IP in terms of, you know that the patent or the technology has been used, it has been licensed, the licensor will receive payments from that, and the technology also will have more value because it has been used, has been disclosed, has been used in the market as a whole. Increase also the incentive of creation and therefore promote greater investment, research, and development. All these topics that I just mentioned are possibilities of a license in a more broad way. But I call your attention from the title of this slide here that demonstrate a history of conflict and friendship. It means that the IP law and the competition law, they could be very friendly or they could be in a conflict. And this is the idea of the whole presentation today. When we jump for the next one, we're going to see that the competition law acknowledges that even the limitation of the use of intellectual property rights may be justified and be deemed pro-competitive. And then sometimes we think that the competition law all the time is going to prohibit something, is going to think that IP should not be protected. This is not true at all. The competition law also stimulates the IP protection and also thinks that certain conditions can be justified. For example, an exclusivity license may be an incentive for the licensee to invest in and develop additional applications for the licensed property. This is just one of the example. But it's true that the IP rights and license agreements may be used as a way to increase barriers to entering the market. If you use the IP in the way that you create a limit, you create a barrier to have some competitor entering the market, and then this is an issue. Another possibility is for close competitors, even reduce their incentives to innovation. These are just some topics as an example that you can use the IP in the wrong way, in the way that the anti-competitive law will think that, well, this is the way that you use the IP to block the entrance in the market, or to delay the entrance in the market, or to do some act that is going to concentrate the market. And this is the time when the competition authorities will bring their attention to the case and create some mechanisms, some remedies or some penalties on the present situation. Therefore, we have to think that IP and competition could be complementary for the protection of both IP holders and consumers, but there may be situations of tensions throughout where IP law will enforce IP rights and competition law will prioritize competition. When we think that the two areas are complementary, is that the two areas has a goal, an achievement, holding the IP rights, but at the same time protect the consumers. This is in IP law and also in competition law. But when you have a tension in the areas that when you have maybe a use of the IP rights as a conflict or as a way to avoid an entrance in the market or block the market or have the power in the market, and then this could be considered a way anti-competitive condition. We have in Brazil two authorities. I would select here the Brazilian Patent and Trademark Office, who has the authority and the role to register IP rights as patent, trademark, industrial design, and also some specific contracts that I'm going to tell in the next slide. And we have the Antitrust Authority, which is called CADE in Brazil, who is the authority in charge to make sure that anti-competitive practices are prohibited. And CADE authorities supervise, examines, and rules the exercise of the markets in power, prevent and blocking abuse in the market throughout the pre-merge control regime and also behavior of control mechanism. We are going to talk more about that later on. How anti-competitive clause may be catch in Brazil? This is basically the heart of the presentation. How a specific situation can be catch in Brazil. First of all, we have to understand the contract system in terms of registration with the BPTO. In very briefly explanation, we have different type of agreements under the big umbrella of technology transfer contracts. The technology transfer contracts could be the trademark assignment and license, patent assignment and patent license, supply of technology. When they call supply of a technology is a technology not protected by a patent, it's kept by a trade secret. We have franchise and technical service agreements. All these agreements are registered in Brazil before the Brazilian Patent and Trademark Office for three purposes. The first one, validate before 30 parts. If you want to make sure that your agreement is valid before 30 parts, you have to register at BPTO. The second purpose that you have to register the agreement is to obtain authorization of remittance of payment abroad. You cannot send payment royalties abroad from Brazil to another country without the authorization of the BPTO and later on with the central bank. And the 31 is the benefits of tax deduction. These are the three benefits and the three purposes that you register the agreements before the BPTO. And when we have the registration of the agreement, the BPTO will make an analysis, not only a formal analysis of whether or not the patent and trademark is registered in Brazil, if the correct number is written in the agreement, if the owner of the patent and the trademark is really the company that is authorizing that use or has any sub-license condition. But the BPTO will analyze beyond that. It's going to analyze some tax implications, some foreign exchange implications, and also some anti-competitive conditions. Of course, this type of analysis has been very discussed, whether or not this is a discretionary power or not, but at the end of the day, BPTO could call attention for certain conditions in the agreement that we're going to see a little bit as one example later on, but the BPTO could call attention certain conditions that they think that this could cause harm for the licensee, for the company that is receiving that license is obliged to pay for that. And in general, what happens is the BPTO will make a requirement, we will ask for additional clarification from the parts, or could even ask to change a specific clause and condition in the agreement, but also maybe could advise CADE that, well, I'm seeing here a situation that could be considered an anti-competitive situation. we are going to see in practical terms, I did not see yet any official recommendation from the BPTO, but the entities has changing information between themselves. On the other side, this is what BPTO, how they act. And then let's see how the antitrust authorities, they act on that. On the side of the antitrust authorities, they have to analyze not only M&A deals. This is the big difference. In the past, the former law and also the people think that, well, just the big transactions or the big M&A deals are subject to CADE, to antitrust authority analysis. This is not true in Brazil. We are going to see what the threshold on that, but we have to remember that sale, acquisition of intellectual property assets, because there is a provision in the law saying that transfer of intangible assets, and of course, the intellectual property or the industrial property are intangible assets. This could be subject to a prior analysis, and also certain commercial agreements, including license of IP rights, could be subject to prior analysis of the antitrust authority. The antitrust clearance is a condition for the closing of the transaction subject to the merge control. And then there is a possibility to also to have some recommendation of remedies in order to approve that transaction. What kind of remedies the antitrust authorities could oblige the Brazilian parties? The sale of the assets, for example, it could require the inclusion, the IP right, the sale of some specific assets, commitment to license on a non-discretionary basis, recommendation to the BPTO, the INPI, to the term compulsory license in IP, any other measure deemed appropriate to solve competition concerns. Therefore, the antitrust authority has the power, has the ability to propose, to impose some remedies to the part in order to approve that control, since when they find a situation that an anti-competitive condition has been created. Just for you to have a sense, the maximum term for the antitrust authorities to review the case and the fine is 330 days. The investigation anti-competitive practice CAD is allowed to investigate any practice that limits competition, represents an abuse or market power, and creates dominance. And then they could go for any projects that goes in one of that directions. Potential sanctions in the prizes found uncompetitive. And then here there's some examples. What are the main concerns in Brazil? When you think finding how the Brazilian authorities see and assess an abuse of IP rights, how do they find a given clause on a license agreement may be abusive or anti-competitive? And then we're going to see that the competition assessment focus on the actual effects of an agreement and not on its formal terms. This is what I mentioned at the beginning of the presentation. We can never look just one specific clause and see that, oh, this is a clause that will call attention for anti-competitive situation. This is going to characterize an anti-competitive situation. Never. You have to look the clause, the agreement, but the whole deal, the whole transaction, the parts relationship, the market power. You have to really go for an analysis of anti-competitive conditions by the competition laws and not only by the IP. The IP could be used as a mechanism to create an anti-competitive situation, but you cannot never look just the IP clause by itself. You really have to understand the facts, to understand the case, and at the end of the day is an analysis case by case. Requirements for filing abusive of IP rights according to the case law in Brazil. This was the Granted case was one of the first ones that we can find what was decided in the case and create a study for us to whether or not there's situations that you have to find this could create an anti-competitive situation. CAD precedent suggests that in order for an IP agreement or any practice involve IP rights to be deemed anti-competitive, it is necessary to prove that the IP holder has a market power. And of course, there is a definition, what is the market power? That it has control, they have the high market shares are important indication. That are structural conditions that allowed unabusive exercise to these powers. And also that there was an abuse of IP rights. And then again, the IP is going to be used in here as an abuse and something that's not on the normal standards of use of IP rights. And then CAD will call the attention in the given agreement. An agreement between competitors. This is something that we have to look at. High market shares held by the parties involved. Licenses granted in market characterized by significant concentration and high barriers to the entrance. Restrictive clause. And then these are conditions that call attention for the antitrust authorities to look in the specific condition. And therefore, what are our spotlights here? Exclusivity. This is one of the topics that call attention, and you have to be careful when you have exclusivity agreement, especially in licensing agreement. Pricing clause. When we have suggested price, that is okay, but when you determine a specific price, minimum or maximum, this is a type of clause that could call attention, that could be characterized as an anti-competitive clause. Patent pools, this also could be considered. Trying, and also grant back clause. Grant back clause in general, the BPTO, remember at the beginning I mentioned to you that there is some clause that the BPTO in general make a requirement or ask for additional clarification or recommendation to the parties. The grant back clause is one of them. The BPTO in general, when they sign an agreement with grant back clause, they make a requirement to make sure that the licensee is understanding what's going on, is understanding what they are giving on that. In general, the BPTO approves the registration of the agreement, but just as a recommendation to look and pay attention in that specific situation. But thinking about the anti-competitive clause and how the antitrust authorities is going to look at, this is one of the clauses that call attention. Again, I'm not saying that these are conditions that necessarily will cause an anti-competitive situation, but these are conditions as a spotlight to be careful and look up. This charter here, I try to compare briefly what's going on in Europe, in US, and in Brazil. Of course, Mark is going to tell much more about US, but this charter here has the idea just to show you that different from US and Europe, in Brazil we do not have a specific guideline. We do not have a specific determination by law as you have in Europe, that will regulate when an agreement or when a condition or when specific clauses are considered or not a condition of anti-competitive. What we have in Brazil is case laws. We have some case, and not many, but some under the analysis or already decide on the antitrust authority process that deals with IP, and when IP was used in the way to block the conditions of anti-competitive. I'm going through one of the case here, and again, these are not, I'm not judging anything, I'm just reporting and inform you as an example the cases. And I try to select different cases with different restrictions that was done by the antitrust authority. The first one regarding exclusivity. This case here between Syngenta and DuPont, this was across a license agreement, a multi-license agreement that the parties proved to CAD after 12 months proving and trying to convince CAD that this was not an anti-competitive situation, this was a benefit of the part and also the whole market, that this cross-license was in the condition that, first of all, there is no control one part to the other, there is no share of sensitive information. They are really cross-patent license for each one develop its own products and new products in the market. They are not competing, they are not, these products without the patent crossing will never be developed, and the consumers, the market in general have the benefits of the cross-license for them. And it was, and Syngenta and DuPont showed that the market could be increased, the introduction of new products, there is no influence by the licensor of the activities of the licensee in any kind of market alliance between them. And because they could demonstrate that to CADE, CADE approved the transaction without any restriction. And this is just an example that even though we have exclusivity, even though we have the cross-license here, it was clearly shown that there is no restriction, the market and the consumers will win with that, and there is no concentration in the market, and therefore CADE approved the transaction. Another case here was Monsanto and Bayer. This is a very complex case with a lot of details, and who wants to study more about the area, this is one of the cases that should be analyzed. But I just want to get one part of the case without going through the whole details of the case. But because of the transaction that was done by Monsanto and Bayer at that moment to sell one of the licensing genetic modified seeds developed by Monsanto, they create a structure in the way that the price and the way that Monsanto and Bayer are going to be paid was a way structured in a specific format. And CADE understood that this format was against competition, was giving benefits only to the parts, and this could be characterized as a concentration. And CADE imposed several restrictions in terms of pricing and remuneration of the case. What I try to select here is that another situation that we did not have exclusivity rights here, but even though we did not have exclusivity rights, CADE understood that this was one of the cases that should be have the remedy applied, and therefore it was requested to the parties to modify the structure of pricing and payment. Another interesting case is patent pools, and this is what case hold in Europe and other countries as well. But this was related to the Blu-ray technology. The Blu-ray technology has a standard technology, and several companies was involved at that time. Several patent owners were involved at that time, creating what was considered the Blu-ray technology. And makes a lot of sense to have a pool of patents in that case to facilitate the license, to reduce the price of the license, to have a better structure of licensing who was interested to observe that technology. And then the parts demonstrate to CADE that this was in benefits again for the consumers and the market in general. And then CADE approved the case without any restriction, also knowing that the patent pool are complementary and not in competition with each other. Only essential patents are allowed. It was also demonstrated that the patent holders are free to license the patent to third parties, and therefore they could have the approval of CADE in this transaction with showing all this evidence here. And then finally, what are the trends for the future in Brazil? As I mentioned at the beginning, we think and we believe that the entities are going to be more connected, are going to share more information, and every time more the competition authorities will look the transaction and see whether or not they are in one of the situations that could be characterized as a anti-competitive clause. I just like to go back. I think I lost one part here, which is important. Sorry for go back on that, but this one, I think I went fast on this one. I just want to show you what kind of agreements are subject to registration with CADE. We have the threshold here are the following. We have certain nature of deals that are subject to registration of CADE. And the nature of the deals are two, as I mentioned. One is the assignment of IP rights of intangible assets, and the other are some type of agreement, which is the licensee will be in that position, what we call associative agreements. And if we have the nature of the deal in one of these, this could be considered a case subject to CADE. But not only that, we have, as you're seeing here, you have a plus. And I try to put this chart in a very easy way to demonstrate to you that there is something in addition to the other. And then you have to think about the nature of the deal. You have to think about whether or not the transactions has effects in Brazil or not. If it's not, then it's not necessary to have any approval of the antitrust authority. And also whether or not the revenue, the threshold is going to be between 750 and 75 million in Brazil. And then if you have the three situations, and if you have and also the three situations, and if the nature of the deals is related with sale of the assets, the IP rights, or the licensing agreement, and then we have a situation that you may need to submit to CADE. And just a complementary information, these associative agreements, the agreement needs to have a term of 2 years and more, plus horizontal overlap where combined shares, 20% or more, or vertical links whether at least one of the parts has a share of 30% or more of the deal, involves either exclusivity or profit or loss sharing. I know that's a lot of information, but just for you to keep in mind that this chart here summarizes what needs to be registered or not before CADE, before the antitrust authority. Of course, I'm focused here just on IP. This is what I have for today. Sorry to go back, but I realized that I missed that. Thank you very much.
Nuestro siguiente expositor es Mark Lieberstein. Él es socio de Kilpatrick Townsend en New York. Su ejercicio profesional se centra en licencias y franquicias de propiedad intelectual en el área de diseño comercial e industrial para varias industrias de distinta índole. Incluye la redacción, negociación y aplicación de acuerdos de licencias y franquicias, y la implementación de objetivos de desarrollo de marca y comercialización para sus clientes. Mark figura y ha sido reconocido en varias ediciones de Chambers USA, también de Super Lawyers, calificado como un Super Lawyer de New York, reconocido en varias ediciones del World Trademark Review 1000, como The World's Leading Trademark Professionals también. En el año 2013 recibió el premio Client Choice Guide International de Lexology, siendo el único galardonado en la categoría de propiedad intelectual en derecho de autor para la ciudad de Nueva York. Ha sido reconocido también por Managing Intellectual Property como un IP Star. Tenemos aquí una presentación muy interesante de Mark que espero que sea de interés de ustedes. Mark, por favor.
Gracias, Cecilia, and gracias to OSIPI for having me. I am honored to be here. And let me shut this. I'm actually wearing it so that if any of you have any questions and you do speak in Spanish, by all means, I'll hopefully be able to understand you. But again, thank you for having me, and thank you, Cecilia. Tatiana, that was a great presentation. Okay, there we go. So I'm going to give you the US perspective, which I think you're all going to hear is not that much different from the Brazilian perspective, except I think the United States has a little bit more rules and laws, which is not surprising. Less taxes, but more laws and rules. So, the introduction. So antitrust and unfair competition laws do apply pretty much across the spectrum. Patents, trademarks, copyrights, trade secrets. I'd even say almost any kind of license of some kind of proprietary technology or any kind of proprietary information or other valuable assets you have. The default position is usually that that license is pro-competitive, meaning that it's not going to be anti-competitive. It's not going to be unfair competition. And then what usually happens, as Tatiana played out a little bit, is something's going to happen in the marketplace. The Department of Justice or the FTC or some other regulatory body or even your competitor will deem your agreement or your conduct in the industry to be anti-competitive, and then the conduct, the agreement, will come under review. The good news is that most agreements in the United States, and the reason why the default position is that IP licensing is pro-competitive, is that there's something called the rule of reason which applies. The rule of reason really is a question. It's, does the agreement, does the relationship between the two parties, is the restraint, or any restraint that may be in the agreement, likely to have anti-competitive effects? And if so, do those restraints, are they reasonably necessary to achieve pro-competitive benefits that outweigh any anti-competitive benefits? If that sounds familiar, Tatiana said it about 20 minutes ago. It's very similar to what goes on in Brazil. So that's the rule of reason. You're going to hear that phrase probably a few times coming out of my mouth during the presentation, because that rule pretty much is applied across the board in almost every situation. I will tell you the situations that it does not apply. So there are pretty much two kinds of restraints / relationships based upon the agreements that are entered into between the parties. There are horizontal restraints, and the relationship or the restraint between the parties is usually between a licensor and/or a licensee, where they would normally be competitors in the market absent the license. So this would be two car companies who are both selling cars, as an example. Now, these types of agreements are not necessarily suspect, nor are they necessarily deemed to be anti-competitive, and usually they maintain a pro-competitive aspect or rationale for any restraint. But there are some horizontal restraints or relationships that are illegal per se. And unlike Brazil, which I think, Tatiana, I saw in one of your slides, where there is no such thing as a per se illegal restraint, there are some things in the United States that are per se illegal for the most part, because many times the rule of reason will be applied. But pretty much the things that are deemed per se illegal in the United States in any agreement are naked price fixing, which is an agreement which says that essentially, sorry about that, I have to hit the button. Agreements among competitors where they literally set the price at which they're going to sell their product. So if the brand owner, as an example, tells the manufacturer, you have to sell this product at $5 to all of your customers, that is an illegal restraint. There are ways to get around that. I'll go through that in a few minutes. But that is a per se illegal restraint. Naked price fixing is what it's called. Then there are output restraints. And this is where agreements among competitors agree to limit the supply. In other words, we're going to get together and we're going to say that we're only going to make 50,000 units. This way the price will stay up, they'll keep the supply low, demand high, and be essentially fixing the price, or at least maintaining the price at a high level so they can make the most profit. The last type of per se illegal restraint are market divisions and allocations. And this is where competitors divide the customers or the products or the territories among themselves and keep everybody else out. Those things are also deemed per se illegal. And again, there are some exceptions to these things, but for the most part, any kind of provision in an agreement will be deemed per se illegal. Now, the other type of relationship, we just discussed horizontal. Let's talk about vertical restraints. Now, vertical relationships, that may be the better type of word. This is where the licensor and a licensee operate at different levels. So we have a brand owner, and then we have a manufacturer, or we have a brand owner and a distributor. So at different levels of the chain in the supply. These are not to be assumed to have anti-competitive effects, and the rule of reason will almost always apply to any type of vertical relationship, with the exception of when there's market power in one of the parties. And market power, as Tatiana very capably described, is when one party dominates the market in some way. Now, tying arrangements. Tying arrangements are where you essentially have your agreement conditioned on a license based upon, for let's say, a set of patented products, and then you require the licensee to purchase unpatented products. And this is deemed to be improper in almost all situations. And it's especially where the desired or tying product provides sufficient market power to restrict competition for the tied product. Now, what are the elements of such a tying arrangement? So the elements of a per se illegal tying situation are where the tying and the tied products are two distinct products. For example, I wrote a note to myself, a camera and the film, even though we don't use film anymore, but it's easier for purposes of this example, camera and film that goes in the camera. two different products, one not necessarily not necessarily needed for the other to be sold, but where one party is selling a camera and then they require you, in order to take a license or have the rights to sell that camera, they require you to purchase their film, or they require you to purchase a certain type of film for the camera. So that's the condition which establishes the tie. So the entity accused of tying has sufficient economic power in the market for the tying product to distort consumers' choices. That means that the only thing that the consumer will be able to buy is the tied product and the tying product together. And if they don't, then they can't get anything. Those types of things are illegal. Market power. We talked about that before, and this is the power to force a purchaser to do something that the purchaser would not do in a competitive market. This is essentially the tying relationship I just described. Because I'm the patent owner and you want to sell my patented product, I have leverage over you sometimes, not all the time, to make you purchase maybe unpatented products. It assumes that I have that kind of market power. But if I'm a sole inventor and I don't make anything and I just own a patent, and I'm requiring you to purchase unpatented products, maybe I don't have market power. And maybe in that situation, even though I'm tying a patented product and an unpatented product together, it may not be an illegal tying arrangement. So I thought I'd give you guys an example of a tying arrangement in the patent scenario. This is a case, it's an old case, but it's a seminal one. And this is where Zenith licensed rights to use a patent by the Hazeltine Research, Inc., in the United States. The patentee conditioned its grant of rights under the patent by making Zenith agree to pay royalties on products that weren't relevant to the patent. This is the illegal tying arrangement. It applies to situations in which the patentee directly or indirectly conditions its license upon the payment of royalties on unpatented products. The licensee has to choose between the package deal or no package deal. That's going back to my example about the camera and the film. If I require the film to be purchased in addition to you licensing the camera, it's going to be a illegal tying arrangement, and per se illegal, if in fact I have market power. Now in the copyright scenario, it happens a lot in the software area where they're tying usually hardware, maintenance, and services to software. So this situation is not that uncommon. So one case that came up is Storage Technology Corp. Versus Custom Hardware, where Storage Technology sold hardware and software for data libraries. Custom Hardware was an independent servicer of that software. Now, Storage Technology had its own repair service and was cutting into Custom Hardware's private independent service business. Custom Hardware claimed that Storage Technology was charging higher prices and to authorize distributors, initiated buyback programs to obtain a larger share of the replacement parts market, and packaged some of the parts together. And Custom Hardware said that that activity by Storage Technology was anti-competitive. The court said no. There was no kind of tying in the relationship that Storage Technology had with its customers. While it was doing some tough competition to keep Custom Hardware out of its business or trying to keep Custom Hardware from competing with it, those things did not impair or impede the customers from having options to get services from other people or to get services from Custom Hardware. And therefore, because they weren't required to buy or license maintenance and service from Storage Technology, and they merely were using Storage Technology, there was no illegal tying arrangement. Now, what about trademarks? Can you have a tying arrangement in the trademark context? I discussed this a lot with some of my colleagues in the firm, and of course you can. An improper tying may result when a trademark license is conditioned on the licensee's purchases of equipment, goods, or services from the licensor. In fact, in the franchise context, many times the franchisor will require the franchisees to make certain purchases of certain kinds of products. Hopefully they don't mandate everything, but if they do, sometimes those things are permitted. And usually there are good reasons for it, like quality control and maintaining the quality and level of service that the franchisor wants to maintain. So normally what that means is that in order for something to really be illegal in the trademark context, the trademark owner has to have sufficient economic power where it uses its brand to compel the purchase of the non-branded products as a condition to licensing the brand. And as I noted before, if we use quality control as the excuse for requiring certain purchases or requiring certain practices, chances are the rule of reason will apply and that arrangement will not be deemed illegal. But here's a pretty decent example, which didn't actually get ruled upon, but it's an interesting example of how, in fact, a tying arrangement or illegal anti-competitive restraint could come up in a trademark case, and it dealt with the Radio Shack Corporation, which, as many of you know, went bankrupt recently. But Radio Shack conditioned Straw Flower's ability to purchase Radio Shack branded products to use the Radio Shack trademark, the tying products, on its purchase of non-Radio Shack brands, which they could have bought elsewhere from Radio Shack, elsewhere cheaper. Now, the court called that a classic tying claim, but of course the claim was dismissed because there was no actual evidence that Straw Flower actually purchased non-branded products from Radio Shack. But it's interesting that that simple arrangement, which may or may not have been justified, and I don't know the answer to that because the case never went forward, but it's interesting how even in a simple context like that, a trademark tying claim could exist. Now, some of the biggest, I guess, let's call them anti-competitive clauses in a license arrangement of any kind deal with pricing. And as a general rule, bilateral agreements regarding resale price are a big red flag for almost any governing authority over any agreement. Now, the courts recently have opened the door to allow some forms of vertical price fixing, especially in the trademark context. And again, it's under the excuse, or let's call it the regime of quality control. In order for me to maintain the quality of my products, I have to keep it at a certain price. If it's at a low price, people will look at my products and deem it to be of less value. And the way this is usually done, remember how I told you I'd give you some options to get around the pricing problem? There's something called the manufacturer's suggested retail price, which I hope most of you have seen. MSRP is the symbol for it. And while it's not necessarily binding on the resellers, in other words, you can't tell the retailer what to actually sell the product for, you can tell the retailer what the manufacturing suggested retail price is. And in fact, you can demand that the reseller show what the suggested retail prices are, even if they discount the product. And so that has been a way in which brand owners and anyone else who's selling any kind of IP asset have been able to sort of not fix prices, but at least let the public know what the prices were suggested to be. And this way, if they're discounted, you as the consumer know, well, oh, I got a good deal, you know, at least makes you feel good. It doesn't necessarily mean that the value of the product is lower. Another even more recent and kind of common practice that I'm seeing more and more is the minimum advertised price, which is kind of what I just described, where you're requiring the reseller, let's say it's Amazon, if Amazon is going to heavily discount the price, it's the price that the reseller will agree to it's the minimum price that has to go on the screen, no matter what they actually sell it for. It doesn't limit at all the actual price. It only limits or regulates the actual advertised price that's on the screen. And it sets a minimum floor for that. Now, here's one case that deals with pricing. It's State Oil Co. versus Kahn. And Kahn was essentially a licensee of the State Oil Company to operate a gas station. And they obligated him to sell gasoline purchased from them at no more than a retail price set by State Oil. Sounds exactly like vertical maximum price fixing. Kahn couldn't make enough money at that price because the price was limited. And so he defaulted on his payments. And he sued. And he said, this is illegal. It's vertical price fixing. The court held that in certain situations, that type of vertical price fixing was not per se illegal. They would look at other factors. In other words, whether State Oil had to charge that price, what were the costs, what's the market look like, what are the other licensees doing, and so on and so forth. So that was a very big case because it overruled a previous Supreme Court decision which said that vertical price fixing was a per se antitrust violation. And even more recently, in 2007, a different Supreme Court case came down and talked about minimum resale price agreements. And those were also deemed no longer to be per se illegal under the federal law. But I caution you all, remember, the United States is not necessarily one country. It's made up of 50 states. And many of those state laws differ. And so 37 states actually in this case, this Legan case, actually urged the Supreme Court to continue to find bilateral minimum resale pricing to be per se illegal. And many states are still trying to get their laws independently followed, and have the attorney generals are actually taking action in California and New York against parties based upon these state law prohibitions on contractual minimum pricing policies. So even though the Supreme Court has said that minimum resale pricing arrangements are okay, you might want to check the state local law and see how active the attorney general is going to be, especially if you're going to be doing business in one of those states. And again, the alternative strategy is to simply make sure that you're requiring your reseller or you're requiring your distributor to make sure they advertise the manufacturer's suggested retail price, to at least let the public know what you think the price should be. Now, price fixing. I think Tatiana mentioned that in her presentation as well. Price fixing, though, in the patent context doesn't always work, because once a patent licensee licenses his patent and gets his royalties, it can't set the prices later on down the chain. It can't control what a subsequent owner does with respect to selling the patented article. It's very similar to the first sale doctrine in copyright. When a copyright owner sells its music, once that sale is made, the person who bought it can pretty much do whatever they want with it. So here's one example, again, an old Supreme Court case in the patent context, where a non-manufacturing company which owned patents on eyeglass lenses licensed it to an affiliated company to manufacture the unfinished lens under the patents. Each of the license agreements in this situation contained a price fixing provision that the manufacturer had to do. The Supreme Court held that arrangement was illegal because the first vending of any article manufactured under a patent puts the article beyond the reach of the monopoly which the patent confers. That's the definition of patent exhaustion. Now, territorial restrictions can also be forms of anti-competitive behavior in any kind of arrangement. It's where you limit the territory in which the licensed articles can be sold. Allowed, for the most part, in patent arrangements, also allowed sometimes in trademark agreements. Again, the rule of reason will always apply, but the point is that territorial restrictions will not necessarily be immune from examination and scrutiny, because if those territorial restrictions prohibit competition, they could be deemed anti-competitive. Other items to watch out for. Okay, there we go. And these are a little bit less common, but things that happen in a lot of agreements that I see. Again, watch out for the state laws. But many agreements also have, and especially license agreements, many times the licensor will tell the licensee that, I'm competing. Thank you. I didn't know if it was coming from my earphone or not. Non-solicitation provisions, where the licensor says, you, the licensee, I don't want you coming after my employees. Well, is that a restraint of trade? Is that a restraint on an illegal restraint on the employee's movement from one employer to another? Usually not, but it depends upon the terms of the provision. Non-compete. I don't know about many of you, but if you've ever done a license agreement, I know that the licensors usually love to make sure the licensees don't make competing products for other brand owners, let's say. Well, that could be also a form of anti-competitive behavior. Although, if you narrowly draft your provision to just be those particular products at those prices, maybe you can get away with making sure that, well, the licensee can't make those particular products at those prices, and therefore that would not be anti-competitive. And then we talked about pricing restraints, and that really, for the most part, are you limiting quantities? Are you some purchasing restraints? Are you limiting quantities? Are you somehow affecting competition in the marketplace by requiring certain types of purchasing restraints? Thank you very much for listening. I will say that the future really probably is in the United States, I hate to say it, the rule of reason. It's pretty much going to be governing from now probably until something else happens. But for the most part, it does appear as if the rule of reason in almost every type of intellectual property agreement is going to govern, unless there's something that is just completely wrong, which is those three items I mentioned before: price fixing, output restraints, supply restraints, and the purchasing restraints, marketing allocations. Thank you all very much. Gracias.
Muchas gracias, Tatiana, Mark. Thank you very much. Tenemos unos minutos para preguntas, así que si están interesados en hacer alguna consulta, una inquietud a nuestros expositores, es el momento ahora. Por favor.
Gabriel Leonardos from Brazil. Congratulations, Tatiana and Mark. Excellent presentations. I just would like to make a short comment. I know it was not the main subject of the presentation today, but in Brazil we have a very interesting development that because CADE, the antitrust agency, has in the last 12 months issued 2 decisions where it condemned companies for sham litigation due to the abuse of intellectual property rights. One case was a big pharmaceutical company that was condemned by CADE to try to evergreen its patents by using sham litigation. The other decision was in a copyright case, a crossword puzzle editor that was using its alleged intellectual property rights to curb competition. So CADE, the Brazilian Antitrust Agency, is right now very active in intellectual property, which only makes us expect that licensing agreements will be also more and more scrutinized. And I don't know if this is a development that's happening in other Latin American countries. I would really love to learn that from the colleagues.
Thank you, Gabriel. Perhaps I can just mention that in the case of Ecuador, we really have no jurisprudence whatsoever on IP-specific issues because our antitrust law just passed a few years ago. So we really need to know and to see what's going on in other countries in order to have some criteria about this. Any other question?
Can I just...
Oh, please, Mark.
Because I can talk about the United States in that particular area. We also have similar sham litigation type of activity in our country. And at least in the patent context, there's a concept called patent misuse. There's also antitrust. If in fact someone is trying to gain monopoly power by using his patents in an improper way and bringing claims that are frivolous, that can really be held against them. There's also a concept called malicious prosecution in the United States, which is not often used, but it is a pretty powerful statute when a party brings a claim for the sole purpose of trying to hurt its competitor. And it could bring not only attorney's fees and costs, but significant damages against either a brand owner or an intellectual property owner in any case. Doesn't matter what type of intellectual property.
Just one comment, I think we have a question over there, but while, as Gabriel and we're just talking in Brazil, the focus here was on the contract, on the clause aspects, the conditions of the contract. But again, I completely agree that every time more and more CADE, the antitrust authority in Brazil at least, they are looking how the IP has been used. As I point out, this has been the trend, this has been what is already going on in Brazil, and every time more and more IP lawyers will have to deal with that together with the competition lawyers to check how the IP has been used and to avoid a use or to make sure that the use of the IP will not be in a position that this could be considered an anti-competitive situation. Please.
Robert Tarochi from Mexico. Mark, what about patent trolls?
What about it?
I mean,
Well,
is the case?
Well, the patent trolls, you know, they're granting licenses a lot. They're not sham licenses, and I think many times the alleged infringers, because many times those cases never get decided, people are entering into those agreements. It's an arm's length negotiation. Yes, it's under threat, But usually what it will probably fall under is the rule of reason. How is it actually hurting competition? If someone takes that license from the patent troll, arguably it's increasing competition. It's putting more people to work. It's putting more products out there. And if a bunch of people agree to take a license from a patent troll, which is generally what happens, then they can all sell and they can all compete and hopefully lower the price for the product. In many instances, the patent troll license agreements are very low value, from what I understand. The patent trolls make money by the volume of license agreements that they enter. And so it's not necessarily anti-competitive. Now, if the patent troll doesn't want to grant a license and literally wants to shut down an entire industry, well, now that may be anti-competitive. So it could have, depending upon what the situation is, it could go both ways.
Yeah, but the patent trolls is an abuse of rights.
I'm
And
sorry?
it's an abuse of rights. I
Well-
mean, you're abusing your right in one hand, and the other hand, seems to me that the patent trolls is the end of the patent trolls because you now have to prove harm.
For an injunction, correct. In the United States, at least, yes. Although, I mean, I don't know if it's an abuse of there are many patent attorneys that would disagree with you on whether being a patent troll is really an abuse. Because at least in the United States, everything goes. It's capitalism at its best. And if the patent troll has spent enough money to buy that patent from its original owner and gets to sue everyone, until the law changes, it's legal. So unless you're doing something that's anti-competitive, which is, if you try to shut down an entire market, I don't know that merely offering licenses as a patent troll would be, in and of itself, illegal. There have to be something more to it. It's a good question, though.
All right. Pues muchas gracias por su atención, and thank you very much, Mark, Tatiana. Have a great afternoon. Buenas tardes.